Hello, this is attorney Dario Romero. I handle immigration and accident cases here in Tempe, Arizona. For this video, we'll be talking about the consular process, what that is, and a little more information about that. So first, let's look at the whole process overall. This goes through multiple stages through different agencies, and the time frame, it can vary anywhere from 2 to 5 years. And it all depends on the circumstances. Each case is different, whether you're inside the United States or from the outside. There are many details. And before you attempt to do this by yourself, get legal advice. Talk to an attorney to see first if you're eligible for this, because sometimes if you do not know, you might not be eligible for this and you go to your interview and you might be stuck outside the United States if you don't do something correctly. Okay, so let's go ahead and start with the I-130. So what is the I-130? So this is the first step where your U.S. citizen or resident relative is petitioning for the person who wants that immigration status. So who can petition for you? That is a U.S. citizen or resident parent or spouse, or a U.S. citizen child 21 years or older. There's also applications if you have U.S. citizen siblings. So depending on the category, there's different wait times, and also depending on the country you're from. The two categories where there's zero wait time is if you're married to a U.S. citizen or if you have a child 21 years or older. The other categories might be subject to the visa bulletin, which means that immigration is posting every month where they are on the application. So sometimes some applications might be a lot sooner, or sometimes there'll be some applications that there are a 20-year wait. It all depends as to the relationship and which country you're from. So the filing fee for this application is $535, and the government can take about anywhere from 6 to 18 months to process the application. So what type of evidence do we need to show? Again, it depends on the relationship. If it's as a parent-child relationship, we just need to establish that the child is the child of the person and that the child is a U.S. citizen. So sometimes it is just the birth certificate that establishes that. Or we need to prove if the child became a naturalized citizen, then it will be like the citizenship certification or certificate. If it's a marriage-based, then we need to supply more evidence. If the couple have children together, then we will include the marriage, the birth certificates that show both of the parents' names on it. Also, any other type of evidence that they live together, that they have established a life. It's not just the moment of marriage, it's the relationship as a whole. So also, if one of the individuals has had a marriage and divorce in the past, we need to establish that the person got officially divorced before they got remarried. Because if they never got divorced and then they got married, there's a great chance that that second marriage is not valid. So you need to have all that paperwork for immigration to be able to review it. So once that I-130 gets approved, it gets sent to the National Visa Center. This process is not that difficult, but it is very detailed. This is where they ask a lot of paperwork, and they want to make sure that you have a financial sponsor. Because in general, when someone's becoming a resident, the United States doesn't want a person who has a serious criminal history, who has an infectious disease, and that they're not going to live off the government. So that's what they do. Fingerprints, they require a financial sponsor, and they do a medical exam. In this step, you submit a lot of those paperwork to show that you are eligible to receive a visa. It is very important to keep contact with this agency less than a year, because if more than a year passes, you might have to pay again those fees. And those fees are $120 and $325. And those are paid online. If 2 years pass without any contact, there is a great chance that your case might be terminated and get sent back to USCIS, and you might have to start the whole process again. So it's very important to keep communication. Also keep your address updated with the National Visa Center. So the next step will be the waiver. For the purposes of this video, I'm going to assume that a person needs a waiver. So a 601A waiver is only for unlawful presence. So if a person entered the United States illegally and they have stayed here for more than a year, then they have the 10-year bar or the 10-year punishment that gets triggered when someone leaves the country. That means that the person is not supposed to come back for those 10 years. So the way to fix that is that we can submit a 601A waiver, and we need to prove that your U.S. citizen, spouse, or parent will suffer an extreme hardship if your waiver is denied. It's very important that there's no waiver from children to parents, but there is from parents to children. That's a huge, huge thing. So we have to make sure that you have a U.S. citizen, again, U.S. citizen or resident, parent, or spouse. So there might be other issues if there's any criminal history, multiple entries, illegal entries. All those things can affect this waiver, and sometimes people are not eligible for that. So before you submit anything, you have to get a legal advice, tell your attorney everything, and that way to determine if there's going to be any issues with this waiver. Other waivers require you to be outside the United States. Again, this is only for illegal presence. So what do we need to prove with this waiver? We have to prove extreme hardship on your qualifying relative. So we look at health, financial, school, family ties, so anything that we can prove that in two situations your relative will suffer an extreme hardship. One, if your relative stays in the United States and the person goes back to his or her home country, and two, if that qualifying relative relocates to the home country with the alien immigrant. And in those two hypotheticals, we have to prove that there will be a financial hardship or a combination of everything, an extreme hardship, that the only way that the person's not going to suffer will be if immigration grants this waiver. This is a discretionary waiver, and it's not a right that immigration has to give it to someone. We have to convince them that that person will suffer an extreme hardship. And the processing time for this case, this type of waiver, can take anywhere from 6 to 18 months, and the filing fee is $715. Now, one of the questions that I receive is, can we use children? Like, let's say if you have a child with special needs. Indirectly, yes. Only if we can argue that the spouse will suffer more economic or more harm or stress or burden without that other significant other, then yes. But directly, it doesn't really matter. Again, we just have to tie it back to the qualifying relative, and that's the way to do it. So let's assume that the waiver gets approved, and then the National Visa Center sends the case over to the consulate. Right now, there is a significant delay in appointments, and it all depends on which consulate you're going to. Also, because COVID happened, it delayed a lot of consulates, and they were closed for a long time. So there is significant delays in a lot of appointments. And again, it all depends as to which consulate you're going. So do expect delays in this process until immigration starts going faster. So once you go to your interview, beforehand you have to do your medical exam. You have to do your fingerprints, and then you'll take all that to the immigration interview. There, the officer will ask you questions to make sure you're eligible, to make sure there's no other issues that you didn't disclose. I like to prepare my clients and do a mock interview, and I pretend I'm the officer and I ask tough questions. But what I've heard usually is pretty straightforward. I always tell clients, do not talk more, do not talk less, only answer the question you're being asked. So if you're coming from the United States, I always tell people that you can expect to be outside anywhere from 2 to 4 weeks. That is normal, assuming there is no issues. Make sure you have an attorney. Request your file if you're not sure about certain details, because you do not want issues to come up at this interview, because if they do, you might be stuck outside. But let's assume everything goes correctly. What immigration will do at the interview, they'll keep your passport, they'll print the visa, and they'll mail it to you to a specific courier. You go pick up that visa, and then you go to the airport or the border, and then they allow you in. Once you're officially in, you are now a U.S. permanent resident of the United States. Once that happens, you can pay the immigrant fee. You can pay that online, and with that, they'll send you your green card. So that's basically, in a nutshell, how this whole process works. Again, this is one of the processes that I recommend that you speak to an attorney before you submit anything, because a lot of people submit documents with document preparers, which there are many who are very good, but also there's some that do not know the legal aspect and consequences. I practice here in Tempe, which is the Phoenix area. If you're in the Phoenix Valley, you can always give me a call, 602-675-7575. If you're in another state, another city or country, call an attorney in your area and they'll be able to give you more information. All right, guys, thank you and have a nice day.